So next question was, when do we step in? When do we step in for care or for finances and doing those things? And, that's very subjective. It's risk tolerance that some people want. Autonomy the desire to be autonomous or to have independence drives our elderly patients and our children, if you have young children at home, to do the craziest, unsafe things in the world. But we have to remember that ultimately their priorities are unlikely to be safety, whereas the most important thing to you might be safety. To them, it's being able to do what they want when they want. Again, just kind of like raising a child. They don't perceive danger in the same way, and they just frankly don't care. They would rather, in some instances, die than not have their independence and get to do what they want. And ultimately, I think when you identify these things early on while they still have capacity, is to just figure out as much planning as you can do in terms of for their safety, their functionality, getting documents done, seeing clinicians and estate planners and all these things, because you don't want to run out of time and not be able to make those important arrangements, because there comes a time in which they would not be perceived of having the ability to make those decisions, and then you're kind of up a creek without a paddle for sure. So with all of these documents, like kind of just reviewing is like kind of what documents should we be doing, what kind of things. You all have to have capacity in order to do these things. And so you likely guys in your other presentations have talked about these things. And so I apologize to anyone where this is redundant. You guys have so many videos in your library that it's hard to kind of capture where there are gaps might be. But ultimately, I think we all need reminders of these things anyways. And these all sort of things that we all kick the can down the road. And then we just need lots of reminders. So if you already know all these things, consider it another reminder to make sure you've got all your stuff done. But ultimately, the types of power of attorney, there's generally kind of two types. There's a general durable and then a healthcare. So the general durable is all the financial things, whereas the healthcare is kind of who's going to make decisions for me, what things I want, what things I don't want. There's ultimately within the advanced directives component of the healthcare, there's also a living will. And basically the living will is the roadmap for the healthcare proxy or your healthcare power of attorney to follow. It's the things that they need to know. And this is not a legally binding document in any way per se, except for naming your healthcare surrogate. If you tell them you do or don't want certain things in your living will, they ultimately can kind of overrule that. So you got to make sure you're picking someone you can trust. One of the jokes I had heard from an attorney many years ago that's really stuck with me is he said that you have to pick someone who ultimately is going to honor your wishes as your healthcare power of attorney. And he said, I don't want to be kept alive on machines when I come to the end of my life. And therefore, I'm going to choose my wife's boyfriend to be my healthcare power of attorney because I know that SOB wants me dead. And just kind of really emphasizes the point of like, if that's important to you, you really got to pick someone who's going to follow through. These documents are only applicable while you're alive, except for the funeral arrangement component within the healthcare power of attorney. Otherwise, these documents have no power over your belongings or anything after you're gone. The standard will, or it is often confused with the living will, and so I'm always talking to people about, the standard will is not the living will in terms of like the things, the car, the cat, the dog, the money that you have. And that is one that only takes place after you die, whereas the living will is while you're alive and what healthcare experiences do you want to have on your journey ultimately. And then there's another component, kind of living trust, which it sounds like you guys have a presentation about in a couple of weeks, which ultimately is kind of all geared around making sure it's as organized as possible and avoiding probate, which there's more tax implications, there's more time involved, there's the courts involved. It just gets really messy really fast. The other document is a kind of call these portable orders, physician's order for scope of treatment. You can find this on the Idaho Department of Health and Welfare website. This is technically not an advanced directive, but it's definitely a kissing cousin as far as I'm concerned. It's an actual medical order written and signed by a physician, a physician assistant, a nurse practitioner. It's an actual order for the ambulance drivers, the ER, whoever's going to come across you in terms of, are you wanting heroic measures? Are you not wanting heroic measures? Advanced airways, level of care, where do you want to be? Antibiotics, there's all kinds of little components in there you can kind of fill out. And we talk about a lot with the learners that I teach, the medical residents and the fellows, is basically everybody should probably have a living will. It doesn't matter how old you are. If you want to pick who you want to make decisions for you, you need to do a living will, naming a healthcare power of attorney. In Idaho specifically, there's a very specific statute that says, basically your court-appointed guardian followed by your healthcare power of attorney. And if you don't have either of those, then it becomes your spouse, then it becomes your adult living children, then it becomes your parents, and then your siblings, and it just kind of runs down this specific list. And so if you've got multiple children or you've got multiple parents who are going to maybe not disagree, whatever it might be, you really have to kind of go out of your way to make sure that the living will names who you want. Whereas this document is this is a conversation between the doctor and you and the future people taking care of you. If you've never seen one of these, real briefly, it basically discusses, in the event that you have no pulse or you're not breathing, do you or do you not want CPR? So up there. And then if you're sick but you do have a pulse and you are breathing, where do you want to be taken care of? And so if you're doing the hospice type of scenario situation where you want to be left where you're at and just kept comfortable, versus if you want to go to the hospital but not get heroic measures, is kind of this option. And there's this big fat box you can write in all kinds of preferences. Do definitely make sure you're thinking thoughtfully about some of these things. But if you wanted to limit blood products, dialysis, antibiotics, any type of other heroic kind of interventions that would otherwise be considered kind of beyond nature, kind of taking care of business, so to speak. And then, of course, feeding tubes. Back to the kind of documents, I did mention kind of guardianship. And so I want to just kind of really quickly review the difference between conservatorship versus guardianship. There is really important to note that doctors and the healthcare team, they determine capacity, whereas the courts, which is who establishes conservatorship and guardianship, they're the ones that make the decisions regarding competency. And so very costly, very time intensive. The conservators basically is equivalent to that durable or financial power of attorney in terms of bills and banking and property and all those types of things, whereas the guardianship controls kind of the person and the healthcare and where they live and the safety and all of those types of things. And so they are two distinct things. They can be the same person, but they are ultimately distinct. You may need one, you may need both. It really depends, and that again kind of is ultimately to the healthcare, or excuse me, is decided in the courts.